say good morning to Susan.
Hello, good morning, David.
Susan, thanks again for joining us this morning, and we look forward to hearing about how Fiscal investigates a case.
Thank you, David, and thank you everybody for tuning in, and it's good to be with you again. And I'd also like to especially thank Michael and Shay for agreeing to take part in this webinar today. So what I'm going to talk about today is I'm going to take you through our process from start to finish. So what happens when a new complaint lands on our desk here at Fiscal, what our case manager looks for, how we go about resolving a complaint, and we're going to talk about a couple of case studies. And I'd really like you, when we talk about the case studies, to imagine for a moment that you are a case manager here at Fiscal, and this is a complaint that lands on your desk. And I'd like you to think about what information would I need to make sure that I fully and fairly investigate this case, and once I've got that information, how would I go about trying to resolve it? But first of all, just by way of a bit of background, as I'm sure you all know, Fiscal is an approved scheme under the Financial Service Providers Act. And in order to maintain this approval, we're required to act fairly when we're investigating and resolving complaints. And that fairness principle requires us to produce decisions that are fair and are seen to be fair. And we do that by making sure that we are observing natural justice and procedural fairness principles, that we're making decisions on the information that comes before us. In other words, we're looking at all of the information that has been presented to us that is relevant to this particular case, rather than looking at perhaps other cases that may have gone before, or taking into account information that the parties have not seen or had a chance to consider. And of course, specifying the criteria on which decisions are based. In other words, making sure that we have given reasons for our decision, so that hopefully both parties can understand why we've reached the decision that we have. So this requirement to act fairly demands that all of our processes, right from the minute that a complaint comes into our office up to the stage that a decision is made, if a decision is required on a case, are fair and are seen to be fair. So in order to do that, obviously we have to give the opportunity for both parties to the dispute to present their cases and rebut material that may have been produced by the other party. We must provide reasons for our decisions, and our actions mustn't give rise to any reasonable apprehension of partiality, bias, or prejudgment. Now, just a word here, we've had a few cases recently where one or either party seems to think that Fiscal's role is to help them argue their case. We've had a few scheme members that say, well, because we're a scheme member and we belong to your scheme, we thought that you would help us present our case and argue our case. And on the other side of the coin, we have complainants sometimes who come to us and think that we are essentially a free legal service, and that we're going to act almost as their lawyer and argue the case. That's not our role at all. We are here obviously to be the independent mediator or arbitrator of a dispute. And I always like to say to people that we're neither an apologist for our scheme members, nor are we an advocate for complainants. We are very much the person in the middle. And while we may well help the parties understand what they need to do to best present their case, and we'll give you some guidance as to the type of information you need to be giving us, we're not going to sit there and basically tell you what you should be arguing, or help you present a legal argument. Just a word here that the dispute resolution schemes, they all have powers to award compensation of up to $200,000 for a direct financial loss, and in our case up to $2,000 for inconvenience, and also power to require a scheme member to take other remedial action, such as perhaps providing an apology. So obviously this is quite a heavy responsibility, and it's certainly, as the ultimate decision maker on complaints, it's a responsibility that I take very seriously. So therefore, every decision that comes out of our office, whether it's what we call a preliminary view letter to the complainant, which is usually where we've written to them to let them know that we're not going to be able to uphold the complaint, or whether it's a formal decision, every one of those letters or decisions has been read, considered, and signed out by me. And that is really obviously to ensure consistency in our decision making on complaints, and that I'm absolutely satisfied that we've reached the right decision on a complaint. I'm just going to quickly here give you a few numbers from last year. So these are the statistics for the year ended 30 June 2016. And I'm pleased to say that less than 20% of our cases went all the way to the final step of a formal recommendation. And as you'll see, only 31 out of those 180 cases that we formally investigated had to have a decision. And of those 31, there were 17 were not upheld. So in other words, we found the complaint to be without merit. 9 were partly upheld, which means that the complainant probably received some compensation or redress, but not everything they were seeking. And 5 were upheld, which meant that the complainant succeeded in full. But first of all, going back to basics, of course, your first priority should really be to make sure that a complaint doesn't get to the stage of needing a formal investigation by Fiscal or your dispute resolution scheme. So make sure that you've got a good, robust internal complaints process, and do your best, if you get notified of a complaint, to resolve the matter through your internal complaints process. And here at Fiscal, we give you tools to help you do that. We've got a manual telling you how to have a good, compliant internal complaints process. We have our Give Us a Call program, where if you've got a complaint that you're dealing with through your internal complaints process, and you're either a bit stuck with what to do with it, or you're thinking of a way to resolve it, but you just want to run your thoughts past someone, then you can get on the phone to us and speak to one of our case managers. And on a without prejudice basis, the case manager will chat to you about the complaint and will tell you, yes, you're absolutely on the right track to resolving this, or if they think that perhaps there are other matters that you need to be considering, or perhaps there's another way that you could resolve it, they'll give you some tips as to how you might do so. And as you know, also we do a lot of training, such as the webinar today, to people on how to avoid complaints, common causes of complaints, and do everything we can to stop a complaint getting as far as having to have a formal investigation by Fiscal. But if the complaint isn't resolved, or your client remains dissatisfied even though you might have made them an offer but they're just not willing to accept it, then you do have an obligation to refer them to Fiscal or your dispute resolution scheme. Now, when you do this, an important thing to have in the back of your mind is that you can always give them a 2-month deadline in which to bring their complaint to us. So that's where the complaint has reached the end of your process, and unfortunately you haven't been able to resolve it, or the complainant is just not accepting what you may have offered or what you have said. You can give them a 2-month warning where you say you must take your complaint to Fiscal within 2 months from the date of this letter, and if you don't do so, then Fiscal will not be able to investigate the complaint. And it's a good tool to have if you really want to draw a line in the sand and make sure that you're giving them this window of opportunity to take the complaint further, but that window of opportunity is limited to 2 months. We find sometimes that if people don't give that 2-month warning, there is always the possibility that the complainant goes quiet for quite a period of time, but then something revs them up again, and 6 or 12 months later, they're making their complaint to Fiscal when you thought that the matter had been dead and buried and your file was closed. So a good way, as I've said, is to make sure that it gets here within 2 months, and that that's the only time they can bring the complaint, is to give that 2-month warning. And if you later on want to have some standard wording to use around that, by all means get in touch with us and we'll give you that standard wording that we suggest you use.
Susan, a quick question on that.
Yes, David.
Is that legally binding on the client?
It is. We've got in our terms of reference that if they've been given the 2-month warning and told the consequences of not coming to us within 2 months. So in other words, it's very important that you say you've got 2 months, and if you don't go within 2 months, Fiscal will not be able to look at the complaint. So you have to give them that warning that if they delay more than 2 months, we can't look at it, then that's legally binding. If you just say you've got 2 months and don't tell them the consequences, then it's not legally binding. So that's why there is some quite specific wording around it.
Right. And does that then, if the client fails to raise the complaint within 2 months, does that then waive all their rights in relation to the issue?
Well, certainly as far as we're concerned, or the dispute resolution scheme is concerned, obviously they can still go to the disputes tribunal or court if they want to.
Right.
But
So
it prevents them having access to the dispute resolution scheme.
Right. Okay, thanks.
And I mean, it's still up to the participant if they want to waive that 2 months. In other words, if someone came to us, let's say 2 months and 2 days after the 2-month period had expired, strictly speaking, we can't look at it, but our scheme member can still say, oh, well, they're just outside the 2 months and I'd really rather you look at it rather than having it go to court. Then the scheme member can waive the 2-month deadline. But it's entirely at the scheme member's discretion. We can't force the scheme member to let us look at a complaint if it's come to us outside the 2 months.
Right, cool.
So it's a bit complicated, so I hope you follow that. But as I've said, I'm happy to give the wording to people later if they would like to have that.
That would be great if you could.
So when do we open a file? Well, we open a file formally here at Fiscal when it's clear that deadlock has been reached, and quite often the client may well have had a letter declaring deadlock from our scheme member, and sometimes obviously with that 2-month warning in it, or where more than 40 days, and that's 40 working days, have passed and the complaint has still not been resolved. We do occasionally see people that have written to their advisor or their financial service provider 3 or 4 months prior to when they come to us raising a complaint, and it's been backwards and forwards and there's been emails and letters, but the complaint still hasn't resolved. If it's been more than 40 working days, we take that as being ample time for a scheme member to have resolved the complaint. So if it's been more than 40 days, we will automatically open the file at that stage. And when the file is opened, it's allocated to one of the case managers in our office. All of our case managers are lawyers and have had some experience in the financial services industry. They've also all had formal mediation training, and in fact, 3 of our current case managers are accredited mediators. And when a new file comes in, they're allocated more or less in the order in which they are received in the office. So if you ever have a complaint investigated by us, basically it could go to any one of our current 4 case managers. And for our case manager, every day is as different and varied as the complainants and the scheme members we deal with. They would say to you that no day is ever the same, and even though some issues are well-trodden paths for us, there's often always a new twist or a new set of facts that keeps life interesting for them. And of course, part of the interesting part of their work is the fact that they're dealing with complaints really right across the financial services industry, apart from banks. So it might be a complaint against an insurance company, it might be a complaint against an insurance broker or a mortgage broker, financial advisor. We have trustee companies, timeshare operators, finance companies and credit unions. So there's a huge variety actually of different types of complaints. and the issues that we see are as varied really as the people that we deal with, which, as I said, keeps life interesting for our case managers. Sometimes when they get the file can already be a couple of centimetres thick, perhaps with a lot of correspondence documentation on it. But sometimes it might simply be a couple of emails or one letter describing the complaint. If it's already been through our early assistance program, then there'll be some correspondence between our early assistance officer, Lauren, and the scheme member. So when they get a new file, our case manager is very aware at this point in the process that we probably only have a very small picture of a long story. So when they get the file, the case manager will obviously think about the issues the complaint raises, whether it's similar to other complaints they've seen, and they will have a good long think about the information they need. And they'll also think about the needs of the parties concerned, because as I've said, we've got a huge range of different scheme members, from insurance companies who are very used to our process, and we investigate quite a number of cases against insurance companies, down to individual advisors for whom this complaint might be their only dealing with fiscal in their entire career, and it might be the first time that they've had a formal investigation of a complaint against them. And we're very aware, of course, that no one likes having a complaint made about them. And if you're a sole advisor or a small business, a complaint can often feel very personal. We aim to be approachable and helpful, and aim to have a constructive working relationship with any scheme member that's had a complaint made against them. And we really encourage you to, even though, as I've said, it's not nice having a complaint made, to engage with us in a constructive rather than an obstructive way, because the process is going to go a lot more smoothly and easily if we can get all the parties working together and trying to resolve a complaint rather than taking a very defensive adversarial attitude. We survey all closed dispute files at the end of the process. We survey both the scheme member and the complainant to see what they thought of the process, to make sure they felt that they had had a fair and independent hearing, essentially, and a timely hearing. And the feedback that we get actually is very good on our closed files. So it does suggest that we are meeting our aim of being approachable and helpful, and obviously fair and independent in the way we go about investigating cases. So the next step of the process is that once the complaint file is opened, you'll get a notification letter from the case manager telling you about the complaint, and obviously you'll already have heard about the complaint because we won't open a file until it's been through your internal complaints process. And we'll be asking you for information at the early stage. Usually we'll be wanting to see your full file relating to that particular client. So we'll want to see obviously your disclosure documentation, any terms and conditions of engagement, all relevant documents such as any policies, insurance proposals, diary notes, and obviously correspondence with the complainant, whether that be email or letter. So just remember, when we're asking for your file, these are your records. We don't know what you have, and we don't know sometimes whether our request for a full file is unrealistic. So if you have something you think is relevant to the complaint that we need to see, but we may not have asked for it, please give it to us. We always say it's far better for us to have too much information than too little information. And sometimes if you're having problems getting all the information together, please call the case manager and talk to them about it. At this very early stage, this is your first chance to tell us what has happened and why from your point of view. However, just a word of caution, it's important to be aware that everything you send to us, we will copy and send on to the complainant, and vice versa. Everything the complainant sends to us, you also get to see it. So it's very important to remember when you're dealing with current clients and making file notes, just always make sure that you write those file notes with a view that one day your client may ask to see them, or we may ask to see them. sometimes we see some file notes that have obviously been written in the heat of the moment and might perhaps contain some language or information that is actually going to cause you a bit of embarrassment down the track if the client sees it. So just make sure, and most of the file notes that we see are very professional and very carefully written, but just as I said, always be aware in the back of your mind that one day someone else may see these file notes that I'm writing. And if some of you have attended my earlier webinars, you'll know how much I stress the importance of keeping good file notes, good contemporaneous file notes of important meetings and telephone discussions. And this is precisely why, because if ever a complaint is formally made against you, this is where we'll be asking for your full file, and we'll expect to see some good file notes on it. And sometimes we get files where there are absolutely no file notes from the advisor whatsoever, and they do raise concern with us, particularly when we know that a meeting has taken place, but there's no record of that meeting. As the professional, we expect you to have good file notes, and obviously, because you're going to be dealing with many tens or even hundreds of clients, it's not going to be possible for you to remember every meeting that you've had, particularly where a complaint might happen 2 years down the track. So again, I really stress the importance of keeping those good file notes. We encourage you to call the case manager at any time in the process if you're not sure what information we're wanting or why we've asked for some particular information. And if you've got something on the file that you think ought to be kept confidential, in other words, not shown to the client, then please do ring the case manager and discuss that with them. Quite often, if there's something on there that we agree should be kept confidential, we can work around that. So perhaps, for example, we might be able to give a summary of what that confidential information is without going into the specifics of it. As I've said, we would just like to keep open lines of communication going. So once we've got the full file, the case manager will always look to see whether a complaint might be able to be resolved very early in the process. So they might be able to see straight away that really a simple apology might resolve this matter. Sometimes when one of our scheme members gets notice of a complaint that's been opened by us, they come back to us and said, look, we've had a second think about this matter, and actually we'd like to make a settlement offer to the client. And obviously we're always very happy if that happens, and we encourage you to do so. And if it can be resolved at that early stage, that's excellent, because the earlier the case is resolved in the process, not only is it more likely to be resolved where both parties are happy, but it will also cost you less as well, because our case fees that we charge on investigations, the earlier in the process a case is settled, the lower the case fee. Sometimes, as I said, the case manager might get on the phone to you and say, look, we think it could be settled by you doing this. And sometimes it may involve a payment of a small amount of money, which sometimes can, if it's paid up front, can save you a lot of time and effort in the long run. Sometimes the case manager might think that the complaint is one that's suitable for conciliation. And conciliation is essentially like mediation, where we bring you and the client together, either in the same room or over the phone, to discuss the complaint. We find that conciliation is really useful in complex cases where there are some grey areas, or where there may be other underlying issues, and particularly where there's still an ongoing relationship that you want to maintain with your client. And in conciliation, it's the case manager's role to help you find a solution. So rather than having a decision imposed on you or imposed on the client, the case manager is helping you and the client to come to a solution together. During the conciliation process, the case manager will often give you a bit of a guide on the way the case is likely to go if it goes all the way to a decision which I make. But they can't tell you what I would do. They can only tell you about the various options open to me, because at the end of the day, if a case has to go all the way to a formal recommendation, it's my decision, not the case manager's decision, it's my decision. We find actually that cases that are resolved by way of conciliation often result in a happier ending than a decision where probably one party is going to be unhappy, depending on which way the decision goes. We find that we have a lot of success with conciliation. We have probably about a 95% success rate. So in other words, cases that go to conciliation settle. And I might just share with you a case yesterday where one of our case managers went down to Christchurch to do a conciliation on a case. And it was a case involving advice given on replacement. In this case, it was a replacement trauma policy. And the complainant had an existing life and trauma policy, and he had a medical condition of cardiomyopathy, which was covered with his existing policy and existing insurer. Now, he met with a new advisor who recommended that the client change insurers, but unfortunately, the advisor didn't check with the new insurer to see whether the new insurer would cover the existing cardiomyopathy condition that the client had, and perhaps more importantly, didn't advise the client not to cancel his existing policy until he could be sure that the new insurer would cover him for his cardiomyopathy. And you can guess what happened. Unfortunately, the existing insurance policy was covered, and then the new insurer said they weren't prepared to cover the cardiomyopathy. Now, the client at the moment is well. He hasn't suffered any complications from the cardiomyopathy, but he's obviously very concerned that at some future date he may have had cause to claim under his trauma policy, and he will now no longer have cover. We thought that this was a case that was suitable for conciliation, partly because the client hasn't yet suffered a loss, and they're always difficult cases for us to determine, so that even if we determined that the advisor had been negligent or had some liability in the matter, until such time as the client actually suffers a financial loss, we're very, very limited in what compensation we can consider awarding. In this case, there was the professional indemnity insurer was involved for the advisor, so the solicitor for the professional indemnity insurer was also in the room yesterday. And to cut a long story short, it was agreed during the conciliation that the advisor would step into the shoes of the new insurer if the client ever has to make a claim under the policy. That is limited, I think, to about $55,000, which was the limit of cover under the policy. So no money has passed hands yet, and no money may ever pass hands, but the client now has the reassurance that if he subsequently suffers a health event related to his cardiomyopathy, he can call on this settlement agreement. And for the advisor, they now know where they stand, and for the professional indemnity insurer, they know where they stand and what the extent of their liability will be.
So the PI insurer has accepted that liability? They
have, yes, right. Yes. And as I said, they were in the room, and we're quite happy to have them in the room. In fact, they need to be in the room, because when parties go to conciliation, we expect the scheme member or whoever is representing the scheme member to have authority to settle on the day. We like to get things, a settlement agreement is drawn up there and then, signed on the day. And our case manager reported that the conciliation went well. There was a really good, frank discussion, and all parties ended up shaking their hands at the end, and the case has been settled without the need to go to a full investigation and full decision, and relatively promptly. So it's
quite an interesting outcome, isn't it?
It is, and I suppose you can say, well, probably apart from the insurer, it's a win-win situation. But even for the insurer, they've drawn a line in the sand now, rather than facing potential litigation further down the track. So they've probably saved, at the end of the day, saved money as well. But if we can't resolve the complaint through more informal means, we will move on to a decision. And the first type of decision you'll see in my flow diagram there is what we call a preliminary view. That is where we have complaints that lack merit, and the case manager determines pretty early on in the process, once they've got the file probably from the scheme member, and perhaps they've had a talk to both the scheme member and the complainant, and they've decided this isn't a complaint that we're going to uphold. So we write a letter to the complainant and tell them we're not going to be able to uphold the complaint. We give them reasons why, and we'll copy that letter to you so that you can see what we've done. And we find that, again, probably about 80 to 90% of complainants accept that preliminary review letter, even though it's bad news for them. Often a complainant has simply wanted an independent third party having a look over the process, having a look at what's happened, and just making sure that what they've been told by the advisor or financial service provider is correct and that there's no liability there. It's another reason why we do encourage people to use our service. If you're having difficulty resolving a complaint within your internal complaints process, sometimes it can actually be more effective and efficient if you think you're on very strong ground, but you're just not making much headway with the client, to actually send the complaint to us. Because often if we agree with you that there's a complaint without merit, we can tell the complainant that, and that then puts the matter to rest, rather than, we see these complaints sometimes that drag on for months, and we think, why didn't this come to us 10 months ago? Because it would have been resolved within a couple of weeks or so and would have saved the scheme member an inordinate amount of time trying to resolve the matter unsuccessfully directly with the client. Right, I'm now going to move on to our first case study, and this is where I'm going to ask for some assistance here from Michael and Shay. So this is a complaint that came to us a year or so ago. We received this letter, which I'll quickly read out to you. It's on the screen there. The complainant said, "Hi, last year we arranged life insurance with David from Illuminate Financial Services. This year we received the renewal and our premiums had increased. We were worried," sorry, there's a typo there, "that we would not be able to afford the increased premiums. We asked another advisor for a quote and it was cheaper, so we cancelled the insurance David had arranged and accepted the new quote. Last month we got an email from David saying that because we cancelled the insurance, we have to pay him $1,725. We did not agree to this. We told David we will not pay, and he told us to talk to you. Can you help? Joan and Barry." So if this letter arrived on your desk, what information do you think you would want to see from David? Michael, Shay,
okay.
Perhaps.
Hey, Michael and Shay, are your mics on?
Yeah. Can you hear me okay?
Cool, yep, all good. Shay, can you? Yep, we're good.
Yep, can you hear me?
Yep, okay, I'll mute myself and so get rid of some background noise.
Great, so for this case, I think that we need to see any documents that were signed which said that they owed the cancellation fee?
Yes, absolutely. That's the first thing we'd be asking for, obviously, David's terms of engagement, and which presumably would include information about the fee. Anything else you think you would need?
What specifically was in that clause, I guess, to determine
Yes.
how much?
I want to know.
Yes. Sorry, someone was going.
I was going to say, I want to know what was involved in the case. So whether he's been in a lot of time or just a few minutes. Fee is warranted as well. I understand it has to be fair and reasonable.
Yes, yes. So we would also, as well as seeing the terms of engagement, we'd also want to see any diary notes from any meetings, because, occasionally people say that there was a meeting in which a fee was discussed and the client was told quite clearly that a fee would be payable. So if that was being alleged by David, we'd want to see notes of the file meeting. So in this case, David actually replied, and he provided his disclosure statement, which had been signed by Joan and Barry. And this was the clause relating to the fee. So it said, I'm aware that Illuminate received commission from various insurance companies for the insurance placed with them. I'm aware that in the event Illuminate Insurance Services receive a clawback of any commissions due to my cancellation or reduction, etc., then I will personally be indebted to reimburse Illuminate Insurance Services for the amount of the clawback and will pay Illuminate within 7 days of their provision of any invoice for such an amount. This was all that David sent to us. He said he didn't have any notes of any meetings with Joan and Barry or any emails. He simply gave us his terms of engagement that included this particular clause. So perhaps I can ask Michael and Shay what they think about this particular clause.
Not very specific. It's
Absolutely
quite vague. Yeah, it doesn't tell you the amounts that could be clawed back, time frames, etc., etc.
Yep, absolutely. I mean, apart from the fact that it could really do with being written in some plain English because it's a very long clause, you're right, it's very non-specific. It also refers to clawback, which is a familiar term, obviously, to those in the industry, but many clients wouldn't have the foggiest idea what clawback means. But more importantly, it doesn't give any indication of what the amount is. So even if a client understood what the term clawback meant, they have no idea whether that clawback would be $1,000, $2,000, $5,000. David said to us that he always tells his customer about the commission clawback, but when he was pressed for details about exactly what he said and whether he gave an example about how much Joan and Barry might have to pay, he was very vague. When we went back to Joan and Barry, they agreed they had signed the agreement, but they didn't remember noticing that particular clause, and they were adamant that he didn't mention commission clawback, and they still didn't think it was fair that they should have to pay a fee. And this is quite common in complaints that we get, where we have very much a he said, she said type situation. So when the case manager is faced with that he said, she said, we always look very closely, obviously, at any written evidence, that is the terms of engagement, file notes, etc. So in this case, we had no file notes, and we had that very vaguely worded commission clawback clause. So we actually said in that case that we didn't think the clause was good enough, that there was no clear evidence that Joan and Barry had been told of the amount that they would have to pay. And after discussing it further with David, he essentially threw in the towel and said that he wouldn't further pursue them for that fee of $1,700, which I think was probably a fair result in that case. And to David's credit, he didn't push it all the way to a formal decision. He agreed that the clause hadn't been particularly well drafted. And the lesson that can be learned from this complaint, and that obviously David learned, is that A, make sure your documentation is very clear, use plain English, make it clear what the fee will be, and again, keep good notes of meetings. If he'd had a meeting note saying that he'd clearly advised Joan and Barry about the fee and had given them an estimate of what the fee might be, then it probably would have been a completely different result. Michael and Shay, any questions on that particular file?
No, I think that's pretty fair.
Great.
Yeah, I think he also just needs to improve his process and just educating his clients.
Yes.
Hey, look, if you're going to want a cheaper deal, call me if you want to make changes. So that's sort of be at the top of the cliff rather than at the bottom.
Yes, yes.
So
All about good communication.
Mm-hmm.
Okay, the second case I'm going to discuss is a little bit of a longer scenario. So this was a case, again, involving advice around replacement insurance. So in this case are the complainants or clients, who I've called Eva and Andre. They had existing life, trauma and TPD insurance with insurance company A. And Andre had $500,000 in life cover, $23,000 in trauma, which was standalone cover, and $500,000 worth of TPD cover. Then in 2012, Eva and Andre met with a new insurance advisor, Richard, about their insurance requirements. Now, the case was slightly complicated because Richard was, I wouldn't say a friend of theirs, but certainly an acquaintance. They had met and knew Richard through their church. And Richard met with them and advised Eva and Andre to move their life and trauma cover to another insurance company, we'll say insurance company B, and replace the TPD cover with income protection cover. The premiums were going to work out slightly less with the new insurance company B. And after meeting with them, Richard left Eva and Andre with the application form and asked them to answer questions in the form about their health. Now, since taking out cover with their original insurance cover, Andre had developed a heart condition. And this was well controlled by medication, and Andre had made some healthy improvements to his lifestyle as well. But the heart condition was not disclosed on insurance company B's proposal form. Now, later on, insurance company B discovered that Andre had a heart condition, and they said that it would no longer insure him for anything related to the heart condition, and they endorsed the policy with that exclusion, and they also, his premiums were increased slightly as well, because obviously there was a higher risk. Unfortunately, by this time, Eva and Andre had already cancelled the cover with their old insurance company. Now, when the complaint came to us, we had two conflicting versions of events. Eva and Andre said that when they met with Richard and they talked about filling out the form, they thought he had said that he would seek a copy of their full medical records to send off with the form to the insurance company. And they also thought that he would tell the new insurance company or seek information from the old insurance company about what information they had about Andre's heart condition. Now, I might just say here that this is not an uncommon thing that we hear in complaints arising around replacement insurance cover. We get a lot of complainants say to us that they think that either the advisor or the new insurance company will automatically obtain a copy of their medical records. It seems to be a fairly common misconception. So just something to bear in mind, that you make it quite clear to clients that the insurer, the new insurance company, won't automatically seek a copy of their full medical records. And I know it's suggested, and it's probably not a bad suggestion, that the client may want to obtain a copy of their full medical records themselves to submit with any new proposal that's going to an insurance company. Eva and Andre also said that when they were filling out the form, Richard asked them the question, "Are you currently healthy?" And they answered yes, because they were at that stage. As we said, Andre's heart condition was well controlled by medication. They'd made changes to their lifestyle, and they were currently in good health. However, Richard said to us that it was clear on the form that Eva and Andre had signed that there was no instruction given to either Richard or the insurance company to seek their full medical records or to give them access to any records that the old insurance company might have held about them. Richard also said that his standard process was to ask clients whether they have ever suffered from any health issues, rather than asking whether you're currently healthy. And also there had been a declaration on the proposal form saying that the clients understood the duty of disclosure. So we've got two conflicting situations here. Obviously, the clients are very unhappy and have a real feeling of disappointment that they've not received the best advice and have been let down by Richard. But Richard's equally adamant that he did all that he needed to do, and anyway, the duty of disclosure was clearly set out in the proposal form. when Eva and Andre came to us, they said that they took on responsibility partly for the situation they found themselves in, but they still felt that they had received not the best service or advice from Andre. They really sort of, from Richard, they felt that they had been let down by him. So here I ask Michael and Shay again, if this case landed on your desk with these conflicting accounts of what had happened, what do you think you would want in terms of further information or further questions that you might want to ask the parties?
Whether the application, a copy of the application was sent back to the clients, I guess, to check, to make sure they've disclosed everything.
Yes, good point, yes.
I'll go ahead.
You go, carry on.
Oh, what was this process around helping the client fill in the forms and highlighting the key clauses or duty of disclosure?
Yes.
And I guess emphasising it's about a total health declaration, so past, present and possible future. Yes,
all good points. And in terms of trying to resolve this complaint, again, this was one where there were a few grey areas once we had all of the information from both parties. And we again had a case where there was not yet any direct financial loss. Fortunately for Andre, he was currently well, and his heart condition was under control. And it may well be that he may never suffer any further problems with his heart. But he and his wife were concerned that, in 5 or 10 years' time, he might have a heart attack or require some kind of surgery, and they wouldn't be covered. So they were feeling a bit uncertain about the future. So I should also mention that, again, the professional indemnifier lawyer was involved in this case as well. So because of the grey areas and because of the fact that this wasn't yet any financial loss, this was again a case that we thought was suitable for conciliation. So we convened a conciliation meeting, which all the parties came to, and again the professional indemnity insurer lawyer. And I should add too that the benefit of conciliation is that everything that happens within the conciliation remains confidential. Even I don't get to see what is discussed in the conciliation. I know what the result of the conciliation was. And the reason for that is that if the complaint doesn't settle, then I have to make a decision on it. So sometimes things can come out at conciliation that perhaps are said on a without prejudice basis, or that might prejudice my thinking on a complaint. So in the 5% of cases that don't settle, I don't get to see what happened at the conciliation. But in this case, the case manager reported that there was a good discussion. Both parties understood where the other party was coming from, and the end result of the conciliation was that a settlement was made of $20,000 compensation. And this came about as a way of giving Eva and Andre some financial reassurance, I guess. They could put that money aside to use in the hopefully unlikely event that Andre would need some time off work with a heart-related condition. For Richard, the advisor, and his insurer, again, it drew a line in the sand. Rather than potentially being on risk for a far greater sum of compensation at some unknown stage in the future, they paid $20,000 now and could move on, put the matter behind them. It may well be that if this case had come to a decision, to me, I might have said no compensation, partly because, as I said, there was not yet any firm of financial loss. But both parties really wanted to have this matter settled and to be able to close the file, basically, and not have to worry about something that may or may not happen 2, 5, 10 years in the future. So both parties were reasonably satisfied with that outcome. Richard obviously would have preferred that nothing was paid, but Eva and Andre were, I can tell you, after a far more substantial amount of compensation, but this was a result that both of them could live with. So I'm just going to move on here because I'm conscious of time. If your case manager, if you do have a case investigated and the case manager does ask you to consider a conciliation, we do strongly encourage you to do that, because we do, as I said, find it a very useful method of resolving a case where there might be some grey areas, or where both parties are wanting to reach a settlement now rather than potentially having something drag on some even years into the future. But unfortunately, not all cases are settled, and some cases do have to go all the way to a formal decision. So if a preliminary view letter to a complainant hasn't resulted in the complaint being discontinued, or if a case hasn't been able to be settled either by way of shuttle negotiation or conciliation, we issue a notice of recommendation. And when we issue a notice of recommendation, it's a bit of a more formal document, which I sometimes say is similar to a court judgment, but not quite as formal. So the notice of recommendation will set out the background events, it will set out both sides' arguments, it will then look at any relevant law or code of practice, and then we will make our decision, having regard to what is fair in all the circumstances, but also, of course, having regard to the law, the terms of any contract, and so on. That notice of recommendation goes out to both parties at the same time, and both parties then have 20 working days to come back to us, either to say, yes, we accept the notice of recommendation, or we don't accept it, we think you've got it wrong, and obviously they have time to present further arguments. I have to say, though, we do tell the parties that unless there is some piece of evidence that we haven't yet seen, or unless you persuade us that we've basically got it entirely wrong on the law, it's highly unlikely that we will change our decision at that late stage. We will have put a lot of work into issuing the notice of recommendation. We'll have gathered all the evidence. A lot of thought and research will have gone into the notice of recommendation. And so we're satisfied when we send that notice of recommendation out that it's a robust document, and that it's the right and proper way to resolve a complaint, whether it be that we've found fault on the part of the advisor and there should be compensation paid, or that the complaint is not one that we're going to be upheld and the complainant should discontinue the complaint. Just a reminder, sorry, David.
On
yes.
that one, Susan, what would be the basis on which a notice of recommendation would be reconsidered?
Very occasionally, there is a new piece of evidence that comes to light, or one of the parties may have omitted telling us something that's absolutely crucial. I have to say we get quite cross when that happens, because we give the parties ample opportunity to present their cases, and we do expect all the relevant documents and basically everything they want to tell us about a complaint to have been given to us before we issue the notice of recommendation. Or very occasionally, somebody might persuade us that perhaps there could be a case that we have overlooked that might persuade us to change our view. But it's very, very seldom, I have to say. The other thing I should mention, that when we're making a decision, we will sometimes seek expert opinion. So, for example, I've mentioned we deal with a lot of insurance cases. Sometimes we might have a case where we're interpreting a policy and it involves perhaps a complex legal issue, or it might be an issue that we think is going to have precedence value. For example, just recently we've been considering a complaint where it was a claim for a rental property that had been contaminated by P. And it's one of the first claims that has been made under a particular material damage policy. And the case essentially, our decision essentially revolves around interpretation of a particular clause of the insurance policy, whether it addresses contamination by P use rather than P manufacture. And because it's quite an important case, because it's going to have obviously application to all future clients of this insurance company that might make claims for P contamination, we sought an independent legal opinion on that from an expert insurance lawyer. And sometimes we will seek expert opinion from other industry participants. So for example, again, we've had a recent insurance broking case where we felt that the service this particular insurance broker had provided wasn't all that good, that he could have done more to make sure his client was insured for the particular event that happened. But we thought, well, maybe we're setting the bar too high. Maybe we are placing too much of an obligation on the insurance broker. So in that case, we rang two other well-respected insurance brokers working in the same field. Obviously, we don't name any names. We just give them the facts of the situation and say, you know, we think that this broker could have done more. What do you think? And they will usually say to us, actually, yes, absolutely, we agree. The broker should definitely have done this. Or sometimes they might say to us, no, you know, that's not standard practice. We think you're setting the bar too high. And we'll have regard to what those experts tell us. Just a reminder here too, and I know this is something that frustrates a lot of people, it's a legal requirement that our decisions are binding on our scheme members. There's no right of appeal, which is another reason why we want to ensure that any decision that we make is robust, is fair, and complies with the law, obviously. But the complainant doesn't have to accept it. They can go off to court or the disputes tribunal. Although we can't be sure, absolutely sure, anecdotally we hear of very few cases that go on to court after they've been to the dispute resolution scheme. The couple of cases that have gone on to the disputes tribunal tend to be in those involving insurance companies. So the client is still not happy that their claim might have been declined. We've probably upheld the decline of the claim, and so they'll have another crack through the disputes tribunal. And finally, we, as with all dispute resolution schemes, we're required to undergo an independent review of our processes at least every 5 years. I'm pleased to say that we had our first independent review a couple of years ago, and this is where the reviewers come in. They will pull out files from our shelves. They'll talk to some scheme members and some complainants that have had complaints go through our process. Again, they do that on a random basis. We don't sort of pre-select people that we think that they should talk to. And we're very pleased that our independent review found that we were meeting all of our benchmarks of fairness and independence, and we're adhering to natural justice principles, and there was no evidence of bias either in favour of the scheme member or the complainant in our decisions. So we were very pleased with that. It's a really good, I guess it's a good reassurance for everybody that uses our service, whether it be our scheme members or complainants, that they will get a fair hearing. And for us, we were very pleased, obviously, that we were complying with our principles and recognised benchmarks. So that's a quick run through of the process, and I think we're almost bang on time, David, but I'm happy to answer any questions if people have got some questions for me.
We are bang on time. Thank you, Susan. Really, really interesting insight into some of the processes that you guys go through when it comes to complaints. We've got a couple of questions, and I think we've got maybe 2 minutes. Carol's, in relation to the first question, which was the clawback fee that the advisor had tried to levy, we talked about the fact that there was some sort of the clause in the advisor's statement was a little too vague, and it was a bit, you know, the client wasn't really informed as to the likely liability. And Carol makes a point which I think is quite valid. It says, how do you know how much to tell the client they might be charged at the beginning of the process if the cost is determined by the amount of time the advisor puts in to get the business on the books? Yes, and that, I guess that comes down to how you're charging the client in that situation, because some advisors will try to claw back any commission that they've lost.
which I have to say, we're not a huge fan of that here. We think absolutely fine that the advisor should be paid for the time and service, but that should be based on an hourly rate and based on the time that they have spent on a matter. But I would suggest that you probably can give the client at least an estimate at the time you're giving the advice. You can say that my hourly charge out rate is such and such. I estimate that my fee on advising you and taking you through the process will be 5 hours, 6 hours, or whatever, and give them an estimate at least. You don't have to give them a firm quote, but at least give them some idea of whether you're talking about $1,000 or several $1,000s, because obviously that makes quite a large difference. It's a bit like as lawyers now, they have to estimate their fees and give hourly charge out rates. So I don't see any reason why that can't be done by advisors as well.
Yeah, I know some advisors say, you know, our fee for placing this insurance on the books is let's say it's $2,000, and that will be offset obviously by any commission we receive.
Yes. Yeah.
So, yeah,
that's fine. It's all about good communication and setting expectations, and setting the client's expectations from the beginning. So many, which I preach all the time, because so many complaints that we come to us is where there's been poor communication, or basically the clients had an unrealistic expectation of something that was going to be done, or that they'd be getting something for free, when quite obviously they're not getting something for free.
Yeah, exactly. I hope that answers your question, Carol. Michael's asked one question as well. Before a complaint arrives at Fiscal, how do you determine that a complaint is resolved? So, you know, maybe there's been some battling to and fro between the advisor and the client, and the advisor thinks that it's been resolved satisfactorily.
Yes.
And yet it ends up at Fiscal. How does...
Yeah, that's a good question. If sometimes we'll know what's going on, because sometimes complaints come to us and we refer them back to the advisor for their internal complaints process. So we've sort of been kept in the loop by the time the complaint gets back to us. But yes, I know it's very frustrating for some people. They think they have resolved a complaint. Basically, if the complaint has already been through the internal complaints process and it falls within our terms of reference, we have to open a file at that stage. And the advisor can then say to us, well, we thought it had been settled, and we'll take a look to see how and why they perhaps thought it had been settled. And this is also an opportunity, which I didn't mention earlier, that if you think you've made a reasonable settlement offer, you can tell us about that. And say, we think we've made a reasonable settlement offer. And if we agree with that, obviously we'll have to talk to the complainant, then we can decline to further investigate that complaint. And we do use that from time to time. We do get some complainants that are very, very difficult and don't want to accept anything. But if we think that the advisor has made a reasonable settlement offer, we'll say so and say, we think you should accept this offer, and we're not going to further investigate it. So we have got that available to us. Sometimes we find that complainants just haven't felt perhaps comfortable dealing with the advisor or financial service provider, and they have been unhappy. But yes, I understand the frustration there, where you think something's been settled. We get it here too, where we think we've settled something, and then one party comes back to us and says, "Oh no, I didn't agree to that," or "I'm still not happy."
Yeah, it's interesting as a challenge, isn't it? Just one point, just before we go, I'm conscious we're just after 11 o'clock. Brent Lewis has said, if you're doing a good job for your clients, why even charge a fee? I've never charged my clients a fee. If they cancel or don't go ahead with me, I put that down to a part of doing business. And I think that, you know, some advisors, that's the approach that they take. Yeah,
swings and roundabouts, and we hear that quite a bit too. Yes.
Yeah. Guys, thank you for your contribution, and Michael and Shay in particular, thank you for taking a little bit of time out of your days to review the cases that Susan put in front of you and give your insights. And Susan, once again, Susan, thank you for sharing the knowledge you have around complaints, and hopefully with this information you will be able to, when you potentially get a complaint or thinking about your process, think about it as in terms of what would happen if a client complained about this particular scenario, and what processes do you need to have in place to try and mitigate the risk of that complaint going awry. So Susan, thank you for your time. Our next webinar, today's webinar is eligible for one structured CPD hour. You'll get a follow-up email, I think tomorrow, 24 hours time, with a link to the CPD questions. So if you complete those, we'll make sure you get that notified on your CPD log. Everybody have a very good weekend, and Susan, thanks once again, and we'll see you back online.
Thanks, David, and thank you again to Michael and Shay. Thank you.
Thanks, guys.